Yeah, so I just want to extend a special welcome to members of civil society that are here with us, members of the media, academics, members of the diplomatic corps and development partners that are here. I also want to extend gratitude to our partners, the University of Zimbabwe Law Faculty, under the leadership of Dr. Innocent Maja. We send greetings from Professor Francis Reilly. Thank you so much for partnering with us. Also, a special gratitude to Zimbabwe human rights lawyers and Zimbabwe NGO Forum, pardon me, and the leadership of Dr. Innocent. Thank you so much for partnering with us, and also thanks to your team for the support in helping us put together this event. As you would know, the Center for Human Rights with our partners, we have simplified the Constitution and Bill of Rights for Zimbabwe. And not only did we simplify it, we also translated it into Shona Ndebele. And the broader aim for this project is essentially to promote human rights in Africa. And I think we can all agree that the existence of a constitution is not a guarantee of constitutionalism. So too is the existence of democracy and certain democratic values. For democracy to be stable and for it to function properly, it needs a constitutional framework of some sort. One that is, of course, people focused, and for constitutionalism to thrive, it also needs a democratic pedigree of some sort. And since 2010, Africa has witnessed a democratic pedigree flourish when we saw a few countries change their constitution. Kenya, for example, Nigeria, and Zimbabwe is among the cohort of countries that have amended its constitution in 2013, and there was quite a lot of citizen participation there. But I think we can all agree that while this is the reality, the recognition, the protection, the fulfillment and enjoyment of fundamental rights in Africa is still remains relatively low, despite the elaborate and comprehensive Bill of Rights that most constitutions in Africa have. And inevitably, what this does is that it leads to human rights violations. And so part of the mandate for this project in particular was to raise awareness. And I think raising awareness is one of the most effective tools, effective ways of enhancing accountability, but also participation in government affairs. I think if a knowledgeable citizen would be able to demand, would be able to question, would be able to seek remedies in an event that there's a human rights violation. And we've done this work both here in Zimbabwe, but also last year we did this work in Kenya, and Malawi, and Zambia. And hopefully next year we'll move the project to Ghana. But what the booklet covers more specifically, as I mentioned, and I always say this, I work at the Center for Human Rights with a bunch of lawyers, and I'm not a lawyer. And I think we can agree that sometimes the law is confusing, right? If you don't understand the law. And part of this is to ensure that the importance of the Constitution is easily accessible to those that may not be able to understand the law. And so the booklets, the Zimbabwe booklets in particular, provides an introduction to the Constitution. It also looks at the rights very simply and explain what those means. And also just to bring some examples, it also covers a few significant cases where citizens claimed their rights by going to court and held either the government or people that have violated them in some way to account. It also offers a summary of rights in the Declaration of Rights, a summary of things like the right to life, the right to human dignity, freedom of assembly and association, privacy, and so on and so forth. what we do want to see is that when you leave here, so I think Terry or my colleague may have sent you an email already with the electronic copies of the booklets, and we will hopefully give you the hard copies before you leave. I always say, do not worry, there shall be no copyright issues. So please, once you receive the email with the link to the electronic copies, just share it widely, because we really want to see our partners in countries that we've done this with taking ownership of this. So share it with your partners. When you get the hard copies, share it with those that you feel that they may want to, benefit. They may benefit from those. So again, I just want to say thank you so much for joining us. In my culture, before you do anything, the patriarch of the household comes and welcome you, and usually would say, you must, well, I won't do the thing, but basically, for you to feel that you're at home, you must take off your shoes first. Please keep your shoes on. And so I'm going to invite Dr. Innocent Maja from the University of Zimbabwe, the law faculty, as I mentioned earlier, that they partnered with us to officially welcome us so that we can breathe at ease. And immediately after Dr. Maja, I'm going to invite the Assistant Director of the Center for Human Rights, Mr. Lloyd Correa. Thank you so much.
Thank you very much for that. I speak on behalf of the University of Zimbabwe, Faculty of Law, which is one of the partners with this particular project. The project is coming at a time where, just a brief background about the Faculty of Law, University of Zimbabwe, at a time where we have transformed into Education 5.0, which is basically heritage-based education that's designed to produce goods and services. And it has 5 missions that it basically looks at. The first mission is the issue of teaching and learning. The second mission is the aspect of specialized research. And in terms of specialized research, what we've done is to create 5 research groups that will develop specialization in the Faculty of Law. And some of those particular research groups relate to human rights, which is involved in this particular project. And then we have constitutionalism and rule of law, we have intellectual property, we have national development initiatives as part and parcel of those particular research groups that are there. And then the third aspect is community outreach or community engagement, where we engage communities to find out what the problems that those particular communities have and try to proffer legal solutions to those particular problems concerned. And then the fourth aspect is the aspect of innovation, and the fifth aspect is also the aspect of industrialization. So it is in that particular background that this is situated. And I think something of public interest as well that I thought I would also mention. We'll issue a public statement very soon. It's coming at a time where, as a faculty, we discovered a leakage of examinations. So I'll talk about this just now. We discovered it ourselves, and then we suspended an examination, and also made sure that we come in and try to address that particular issue that's there because of the integrity of the examination process. So investigations are ongoing. I'm sure once we have results in that particular aspect, we'll formally communicate, we'll officially communicate in that particular regard. So just to dispel some of the needs that have been coming. That's a time when this particular conference, when this particular launch is coming in. Allow me to thank the Center for Human Rights, allow me to thank Zimbabwe Human Rights NGO Forum, allow me to thank the University of Pretoria for coming up with this particular interesting project. I think it's important for us to, when it comes to human rights, it's important for us not only for citizens to know the rights, but also to be able to enjoy those particular rights, and more importantly, in the event of violation, to be able to find redress whenever there is violation of those particular rights. And I hope the launch of this particular booklet and the participation that comes with it will enable citizens to do that. With those few words, allow me to say welcome and thank you. I hope we have a good time today. Thank you very much.
Thank you very much, Dr. Majo, for your welcome remarks. Indeed, it's always been a pleasure to partner with the University of Zimbabwe on a variety of projects as the Center for Human Rights, also being an academic institution based at the University of Pretoria. So, really appreciate that partnership. So, just also want to say welcome to everybody who is coming from civil society here in Zimbabwe. People who have come from the law society of Zimbabwe, media houses that are here present. We welcome you, and we hope that you are going to cover this event as objectively as possible. We also welcome members of the diplomatic corps represented here. I've seen quite a few people coming from a number of embassies. Members of the donor community who are also here. I've also seen a couple that are here present. We welcome you. I've also seen representatives from different universities. You are very welcome here, and we hope that this discussion is going to be very rich and is going to be very fruitful. So let me just also say a bit about the Center for Human Rights, for those who might not know about the Center for Human Rights. Before I give a brief presentation, where I want to set the scene for the discussion. What I'm going to say, it might not be very intellectually profound. The person who's going to say the more intellectually profound issues is my good friend and the director of the forum, Dr. Musa Kita. He will be giving the key of that place. And what I will do is just to set the scene so that we give context to the deliberations that we're going to be having today. I'm also happy that Ivona Matai, she's been one of the very active civil society activists in Zimbabwe. I think she's also on the program to present, and my brother Blessing Namaropa from the Zimbabwe Lawyers for Human Rights. So I think we're going to have very rich presentations, both from a theoretical perspective, intellectual perspective, from a practical perspective of activism. And I'm really looking forward to an exciting time today. I just want to talk now about the Center for Human Rights. So the Center for Human Rights is a hybrid institution. We are unique in that way because we are an academic institution in the sense that we are a department of the University of Pretoria, located within the Faculty of Law. And in that regard, we run 5 master's programs, LLM programs, but also in these LLM programs, we also invite persons who might not be lawyers, but who want to study human rights and international law. So there's the LLM part, and then there's the MPhil part. So you can find that in a class of 30 people, you might have 20 or 25 who are lawyers, and then maybe 5 or 10 who are non-lawyers. So these are the 5 master's programs that we have. We also have doctoral programs. At any given time, we have maybe not less than 15 PhD students studying in the Center for Human Rights, looking at different issues on human rights. Then also on the academic side, we run about 10 short courses that happen every month of the year. And those short courses run for 5 days, and you don't have to pay anything to do those short courses. They are conducted both online as well as in person. If you want to come to Pretoria, of course, you really have to motivate and justify why you should attend in person. And if you are unable to get that recognition, then you can still attend online. So I would encourage everybody here who is interested to just have a bit of interaction with other colleagues around the continent. I think that's the beauty of these programs, that we get people from around the continent, the whole of Africa. These are rich programs. So that's the academic side of the Center for Human Rights. The other side is that we are also an NGO, in a way. And so the NGO side of our work is that we focus on vulnerable people in society. So these projects, they are looking at all these vulnerable people and looking at how we protect such vulnerable persons. And we are doing this around the continent. So the center also has this Pan-African outlook in that we just work all over the continent. And some of the units that I can talk about, of course, I think the other unit, obviously, is the Democracy and Civic Engagement, which Bonolo leads, and they've been doing amazing work. And I'm so excited that we are coming here today because, as Bonolo has said, we did Zambia, Malawi, now we're in Zimbabwe. So we're completing the former federation countries, isn't it? So we've completed now those 3 countries that were in the federation long back under the leadership of Cecil John Rhodes and these people. So now we are now in the post-colonial stage where we are now looking at our post-independence constitutions that are more expansive, that are more protective of human rights, that are not protecting the vested interests of the colonizer. Hence, we are looking at the 2013 constitution, which Dr. Musa Kika will run you through in greater detail. So that's the democracy unit. That's one of them. The other one that I can talk about, we have a unit that looks at persons with disabilities, another one that looks at children's rights, another one that looks at women's rights, another one that looks at migrants, internally displaced persons, asylum seekers, and stateless persons. So I think for us, we had a very deliberate choice of looking at vulnerable, marginalized, poor, indigent persons of our society. And in that regard, we always try to say, how do we fight for their rights and ensure that their rights are protected? So those are there are 10 of them. I don't want to mention all of them. If you are interested, you can always visit our website and have a look for yourself and see, all the 10 projects that we work on. And so our advocacy usually is focused at the regional level, the African human rights system, and also at the United Nations level. That's where we do most of our advocacy. But also for us, we believe in also looking at the local environment. So we also believe in doing advocacy at the local level, and hence the reason why we are here today, and really excited with the partnership that we have established, as has been mentioned already by Bonolo. Now, let me set the scene. Why are we doing this? Why are we really coming up with the booklets on constitutional literacy? When in fact we have the Constitution written, the 2013 Constitution. So for us, I think I don't want to go to the detail and the background which Bonolo has given, but I just want to say that when you look at the Lancaster House Constitution that we had for so many years before 2013, it contains some elements of liberal democracy and checks and balances, but it also mainly focuses on retaining provisions, protecting the interests of the colonizer, isn't it? And therefore, it was very important for many of the African countries to then come up with new constitutions that are more expansive, that try to promote the independence of institutions like the judiciary, that try to promote rights in a very expansive manner, that try to look at the rights of all citizens in the country, that tries to address issues of governance, promoting good governance, and so on and so forth. And this new post-colonial constitution in the form of the 2018 constitution, I think there was great participation. There's arguments as to whether or not there was meaningful participation by the people of Zimbabwe. But I think there was that level of participation. And in a way, that participation contributed to constitutional interests, isn't it? So when you participate in the writing of the constitution, in a way, you are also made aware of the provisions of the Bill of Rights, in a way. But why is it therefore important for us to talk about constitutional literacy? From our perspective, constitutional illiteracy is a threat to democracy and constitutionalism. Because if people are not knowledgeable, it means that we might have a process where there's retrogression in electoral democratic processes. So people are not able to choose their own leaders. They might not be able to participate politically. Opposition political party activists might be persecuted, and so on and so forth. But if people then have this constitutional literacy, they are able to vindicate their rights and fight for their rights and ensure that they are able to participate at a political level. And so I think for us there is no doubt that the strengthening of democratic constitutional foundations that have been laid by the 2018 Constitution with a focus on the poor, the vulnerable, and other marginalized groups, it was a very welcome development. But without knowledge and awareness of the rights that are in that Constitution, citizens really won't be able to vindicate their rights and to challenge any violation thereof. Not much is written on the extent to which ordinary persons today are aware of the extensive rights that are in the Constitution. Some have tried to do so, but not much has been written. So I think for us this project will help us to show whether or not people are aware of their Constitution. I just want to give a case study of South Africa, then I'll sit down in terms of what has happened in South Africa around constitutional literacy. So with South Africa, there was active citizen participation in the constitution making process. And I think the same has happened in Zimbabwe, isn't it? And then you look at the writing and adoption of that constitution, the participation of people who were fighting against apartheid, who were involved in the drafting of that constitution. Also in South Africa, there was extensive and inclusive public participation, and the constitution was translated into 11 languages, including Braille. So essentially 12 different languages, if you may. The question then is, did that result in constitutional awareness or constitutional literacy? The sad reality is that we don't know, actually. In 2015, there was a study which was carried out, which revealed that 46% of the South African population knew about the Bill of Rights, and only 10% had ever read the Bill of Rights. So, I don't know as Bono has said whether I should blame lawyers for putting the constitution in language that many people do not understand. That's why we pay lawyers, isn't it? That they can sort of try to interpret, and then we have to go to court and the judges to interpret what is the content of the rights. Also, what happened in South Africa in terms of, after they realized that not many people are aware of the Bill of Rights, the Department of Justice then started a program of constitutional awareness and literacy. I remember 5 years ago, Mr. Mdenda, the Speaker of Parliament, saying that I wish civil society would come up with a simplified version of our Bill of Rights, and we take it to the people. We have to go where the people are. And I think this is an answer to the clarion call by the Speaker of Parliament. We are doing it now, and I'm glad that we are doing it as civil society, as an academic institution. And this is why, for me, really, the partnership with the University of Zimbabwe and the Forum is really amazing that way. And also the civil society organizations that are here present, we can then take it to the people, isn't it? Because it has been now translated. It's not just about the translation, but the simplification. If you look at, you see the booklet. I mean, it's also online, and just to share with you. It's just amazing. It's so simplified that any person can understand. For instance, what does the right to a fair trial mean? For instance, I think right to a fair trial, let's just talk about that one, because it's one of the things that are affecting Zimbabwe at the moment. So for instance, as a person, you need to know that right to a fair trial means that you have a right to be presumed innocent, isn't it? You can't be persecuted from the onset, you are being tortured, you are being denied bail, you are in pre-trial detention for 6 months on end, no trial is happening. You know, and you begin to wonder, where are the courts when all this is happening? Okay? So you should know then that your right to a fair trial has been affected. You have a right to a speedy trial, especially if the offense that you are being charged with is a very simple and straightforward one. You see now. And there's no need for someone to be held in detention whilst waiting for their trial if you are a citizen of Zimbabwe and your what you call it, your address is known. You know what I mean? You are not a flight risk. Why should you spend months on end awaiting trial? And I think there's some of the issues what we are seeing in Zimbabwe. So if a person who is in Shikurubi and they don't even have legal representation, they can't afford it, if they know their right to a fair trial, they can challenge this in the court when they appear on their next remand day, isn't it? You say, look, I have a right to bail, I have a right to be tried within a reasonable period of time. I shouldn't be suffering whilst awaiting trial on remand. So these are the things that the Department of Justice in South Africa did to train everyone. Also, and I don't know whether there are people here that are from the Judicial Service Commission, especially the Constitutional Court. The Constitutional Court law class in South Africa also ran a program where they were training students in high school and university on the Bill of Rights. That's one thing that can be done by the law clerks here in Zimbabwe at the Constitutional Court and the Supreme Court. There was also a life orientation high school curriculum which was developed by the Ministry of Education to teach high school students. And you need to start when children are still young, isn't it? I mean, there was a time we went to Geneva at the UN, and we saw a lot of these young people visit the United Nations to know about the Declaration of Rights, to know about all these things. And you are never too young to know about your rights, isn't it? Because, I mean, for instance, we have the issue of corporal punishment when our courts declare that corporal punishment is unconstitutional. Children need to know about this thing. They also have the right to know what their rights are in the Constitution. Then one of the most, I think for me, innovative projects in South Africa is the National Schools Moot Court Competition. And it's done every year by the South Africa Human Rights Commission in partnership with universities. Currently, the University of Pretoria is partnering with the South Africa Human Rights Commission to get students to come and argue cases based on the Bill of Rights. And the final itself is actually held at the Constitutional Court before real judges. So for me, I think there is no better training than that for young students in high school to know about their constitution and so on and so forth. Then, of course, the South African Human Rights Commission has also done workshops, community support engagements, teaching people in the communities about the Bill of Rights. So, in other words, what I just want to say using this example or case study is that all of us working together can do so much to get people to know about their rights. The civil society, academics, the independent commissions like the South Africa, the Zimbabwe Human Rights Commission. I don't know if they are represented here today, but so this is the sort of thing that we can be doing. The university with these legal clinics and so on and so forth, they can do that work as well to train so many people out there. When we do that, then we are going to ensure that we have got effective and participatory democratic system in South Africa. We will have an independent and efficient judiciary because everyone is challenging and exposing even the judiciary if they are not doing their work. We have effective constitutional commissions. We have a vibrant parliament, adherence to rule of law and respect for human rights. Civil society space is respected, not restricted. I think we've seen already in Zimbabwe that sort of retrogression where there's been attempts to restrict civil society space, which is really, for me, an anathema to democracy. And it also means that there's not going to be vibrant CSO involvement in awareness raising, public interest litigation, and doing work on constitutional interests. What I want the government to understand is that civil society organizations are not enemies of the state. Civil society organizations and the Human Rights Commission are there to partner with the state in advancing the rights of the most vulnerable members of community. I think for me that's the most important thing. The most vulnerable and marginalized members of community. And if we do that together with government and so on and so forth, then we'll achieve much. Thank you so much for listening. I hope I wasn't too long. I just wanted to set that scene, but you're going to hear more from our keynote speaker and the other speakers that are coming. Otherwise, welcome and enjoy this day, and I hope that you're going to enjoy the booklet that has been done by the Center for Human Rights.
Thank you, Lord. I think the Minister of Justice in South Africa will be pleased to hear that at least if there's anything, you agree on this idea of constitutional triumphalism in South Africa. And I think one of the things that you've mentioned that I think is key is the importance of state actors and non-state actors working together, and this idea that civil society organizations are an enemy of the state. I always make this example that in theology there's a thing that they call humanities of suspicion, where you are suspicious of everything, you are suspicious of people. And I think in reality there's this suspicion that the state has when it comes to civil society, and that we are an enemy of the state. And I think part of the work that we do at the Center for Human Rights is working with various organs of the African Union to demystify this idea that we are an enemy. Thank you so much for this reflection, Floyd. I'm going to welcome the Deputy Director of Zimbabwe Human Rights Lawyers, Mr. Blessing Yamaroba. I hope I pronounced your name correctly. And he's going to just reflect with us on the role that the court can play in providing a binding ruling on such actions around how the Constitution plays out and the role of the court like that.
Thank you, Master Simon, for giving me the opportunity to speak on this very important occasion. Let me congratulate the Center for Human Rights and its partners for coming up with this booklet, which simplifies the Bill of Rights. I think it's a milestone in our system, because this Bill of Rights should not remain in that big book that we call the Constitution. I think the purpose of this Bill of Rights is that whatever is contained in that section, the generality of Zimbabweans, the citizens of Zimbabweans, should be able to know. After knowing, they should be able to demand and assert what is contained in that Bill of Rights. The Bill of Rights is a very important component of our Constitution. If you want to look at the Constitution, the architecture of the Constitution and how it is written, it provides the framework of government, it establishes institutions of government. But when you locate the Bill of Rights, or when you look at the Bill of Rights, it is framed in a different way. It puts individuals at the center. That's how important the Bill of Rights is in our Constitution. It focuses on the individual. It also focuses on the relationship between the state and individuals, and how the state should be able to treat its citizens. Our 23 Constitution, 2013 Constitution, it goes a long way in terms of establishing who has the mandate to respect human rights in our context in Zimbabwe. So you find that our Constitution, in terms of the Bill of Rights, it goes beyond the state. It also requires individuals, corporates, all government agencies at all levels to respect human rights, which to me is fundamental and is key, because things have evolved over the past. Previously, previously it has always been states as the violators of human rights. But now we also have powerful corporates, we also have powerful individuals who can also violate human rights. And our Constitution correctly places an obligation on everyone to respect human rights. Section 85 of the Constitution embeds the commitment to enforce fundamental human rights and freedoms in Zimbabwe. The law expressly outlines that an aggrieved person, member, or association is entitled to approach a court to allege when a right has been violated or is about to be violated for a remedy. Not only does this clause provide unprecedented support to persons seeking recourse, but emphasizes the court's duty as a guarantor and protector of human rights. It is in this regard that the courts cannot be found in detriment of inherent rights and redress. So in our context, maybe it's a soccer match or something, you'll find that we have a referee that is there, which are the courts. And the courts have been given with mandate in terms of our Constitution to be able to be the referee when the rights are about to be violated or have been violated. Section 85 also highlights that the courts have an obligation to effectuate fundamental human rights and freedoms to all individuals. So the court's role in protecting and enforcing fundamental human rights and freedoms is not illusionary. On 2 occasions and many other occasions, the court was seen to demonstrate its duty as custodian and enforcer of fundamental human rights and freedoms in Zimbabwe. Although our jurisprudence in terms of human rights protection by our courts is still not at that level, when you want to make a comparative analysis with other jurisdictions like South Africa, India, and others, where we have a lot of jurisprudence in terms of protection of human rights, but you'll find that we already have a mechanism that is in place, that is provided for by the Constitution, where victims, where citizens can run to when they feel that the Bill of Rights is about to be violated or has been violated. In Zimbabwe, we have also witnessed progressive cases that have been taken to our constitutional court, and some determination have also come out of those of our constitutional courts. And as Zimbabwe Lawyers for Human Rights, we have managed to litigate either at the High Court, at the Magistrate Court, and at the Constitutional Court cases of human rights protection. Because our Constitution doesn't really limit jurisdiction, of course, to entertain issues that have to deal with the Bill of Rights. So you can go to these courts, but what differs is what remedy can be provided by the court that you have approached. And also there are certain matters that you cannot take to the lower courts, but matters that you can take to the Constitutional Court. In 2016, in the Muzuru case, I think we've all learned about the famous Muzuru case, which involves the issue of child marriages. I think it's one of our most celebrated cases in our jurisdiction here in Zimbabwe. The court dealt with the question of whether the applicants had local standard to engage in public interest litigation to enforce their rights. The courts made use of its powers to interpret the Constitution Constitution and the Bill of Rights, and also issues to deal with who can come before it when the case. And just to note what came from the court. The right to access to justice, which itself is a fundamental right, must be made available to a person who is able to, under each of the rules of standing, to vindicate the interest adversely affected by an infringement of a fundamental right, and at the same time enforcing the constitutional obligation to protect and promote the right concerned. I think we all know the judgment that the court went on to give in that case. We have also brought before the court some cases. I think you remember the Farah Mushoriwa versus the Sito Farare case. I think we all know the water case as it has been called in some quarters, where the court also demonstrated who can approach it for a remedy when there is a right that has been violated or is about to be violated. So you find that more cases have also been brought, economic, social, and cultural rights, although we are still yet to fully develop our jurisprudence in that regard. To those who have been following developments at our constitutional court, we have heard of the case of Mugunguruse and others, versus Sito Farare and another. In this case, the territorial lawyer sought to uphold the right to shelter as protected in Section 74 and 81 of the Constitution. The High Court and later the Supreme Court confirmed that Section 74 of our Constitution requires a court order, requires that no one can be arbitrarily evicted from their place of residence. And in that case, lawyers successfully litigated the case, which struck down the purported arbitrary eviction of citizens. You also recall the case of Peter Makani versus Airport Local Court, Clifford Charera versus University of Zimbabwe, and two others, and many other cases. I think those who have been following these cases, you also know that Section 74 was also interpreted in those cases, and the courts stopped some certain actions that were viewed to be in violation of Section 74 of our Constitution. You also recall the case of Homeless People's Federation and others, versus Minister of Local Government and National Housing and others. These are some of the cases, among many other cases, that have been brought before our constitutional court when issues of some of the economic, social, and cultural rights were brought to test before our court. And we also have other cases, Ifrem Matanda, and United Mutare residents, the Ratepayers Trust versus City of Mutare. This is a water case which involves also the provision and the obligation to provide water by City of Mutare. And also, you recall the case of Amalgamated Rural Teachers Union of Zimbabwe and another versus Minister of Primary and Secondary Education, which those who have been following up will be able to know what happened in those cases. The point that I am trying to illustrate by mentioning some of these cases is the important role that courts play when it comes to protection of human rights that are contained in our Bill of Rights in Zimbabwe. Of course, we have other mechanisms that are available, which are not courts, like commissions that have been set out in terms of the Constitution, like the Zimbabwe Human Rights Commission, which is a mandate to protect and promote human rights that are contained in our Bill of Rights. So that is another mechanism that is provided for in terms of our Constitution. Despite the role that the courts can play in protecting our human rights, especially in our context here in Zimbabwe, I think what is a cause for concern to us is that we still have very few people who are approaching these courts for remedy, despite their rights, which are protected under the Bill of Rights, having been violated. And I think that's when this booklet, which is being published today, will come hand in trying to popularize the Bill of Rights. And I understand this booklet is translated in some of our vernacular languages, the Shona, Ndebele, and so on. So I think it's key that there is a relationship between citizens utilizing the mechanisms that are available, which are the courts, and other mechanisms that I mentioned, like the independent commissions, like the Zimbabwe Human Rights Commission, and information raising or raising awareness. Because at the end of the day, if we have the Bill of Rights and the citizens of this country do not know what is contained in the Bill of Rights, it means even if there are violations, even if there are mechanisms that are available, like the courts, the commission, they will not be able to utilize these mechanisms. They will not be able to seek redress when their rights have been violated. So I want to, like I said in my opening, I like to commend the center and also its partners for this noble work. We know that some other publications have been done, and your work will complement the already existing literature that is there in our country in terms of popularizing this very important section of our Constitution, which is the Bill of Rights. So there still need, like I said, to bring more cases before the courts so that state obligation is clearly defined. Because if you find even some of the social and economic rights that are protected in our Constitution, if they are provided, of course, we have international framework that is there, we have regional human rights framework that is there, that tries to define the content of these rights. But it will be good in our context to have the content of the rights that are provided in our Bill of Rights, especially economic, social, and cultural rights, being clearly defined. When we are talking about the right to education, what are we talking about? When we are talking about the right to water, what are we talking about? What are the elements? When do we say the right to water has been violated in our context in Zimbabwe? When we are talking about the right to food, what are we talking about? What are the elements? What are the content of that right? At what stage can a citizen be able to approach these mechanisms, right? Because to allege that there has been a violation of the right to water, there has been a violation of the right to food. So to me, it is key. And only these mechanisms that are there, they will be able to play their part when citizens bring cases before them. In finishing, let me finish by saying there is also need for courts to build jurisprudence in human rights protection, moving away from technicalities to deal with substantive human rights issues brought before them, so that we are able to build our jurisdiction, our jurisprudence in Zimbabwe, and citizens are able to come before these courts for protection if there are any violations. I thank you.
Thank you so much, Mr. Yamaropa. I think it's important to know that the Constitution of Zimbabwe provides for all constitutional obligations to be performed diligently and without delay. And I think the work that institutions like Zimbabwe Human Rights lawyers are doing is quite significant. So we're going to move on. And just before I call the next speaker, I do want to say that, and I made this to contextualize why we particularly have this next speaker on the program. The fact that Africa has the largest population of young people in the world. In fact, as of 2021, the youth population in Africa has been estimated to be just over 40% of the total population of the continent. And this then makes this a very young continent. And there's always been things about this idea that we must mobilize young people, and I often push back that young Africans are mobilized. Young Africans are doing a lot in South Africa, in Kenya, in Zimbabwe, in Nigeria, in Egypt. We see quite a lot of the significant work that is done by young people across the continent, and the challenge is that they are not engaged. And so when we also think about this idea of taking the Constitution or the law to people, how do we do that, and how do we recognize the important role of young people in shaping the kind of democracy that we want to see in Africa? And so I'm going to welcome Ms. Namatai Kwekweza, who's the Executive Director of Lead Trust, and I just really hope that she can help us reflect on the importance of accessibility of the law to citizens in the protection of their human rights. Because I think we can also agree that there are a whole lot of other implications in how citizens are struggling to access the law, and one of them being, funding. It's quite costly to go to the courts. It's quite costly to pay for lawyers. But so I'm hoping that you can also, through the lenses of as a young African woman, through that lens, that what does it look like for us to take the law and make sure that the law is accessible to young people on this continent. So welcome.
Fantastic. So, thank you very much. It's really exciting to be here. And I just wanted to congratulate all the organizations that have teamed up. The Zimbabwe Human Rights NGO Forum, the University of Zimbabwe, the University of Pretoria, as well as the Center for Human Rights. I think it's really splendid that we have such initiatives taking place where there are deliberate efforts that are being made to ensure that the Constitution is accessible, the Constitution is easy to understand, and is available basically to everyday ordinary people who otherwise would not have this privilege, and it shouldn't be a privilege anyway, to actually know more about the Constitution. So at the organization that I work, it's called Lead Trust. We have a campaign that we've been running for the past 1.5 years. It's called Constitution Culture. And fundamentally, we look at the Constitution from a place of saying, culture is a people's way of life, right? So if we talk about Constitution culture, we're basically talking about people leading the Constitution. Because at every given interaction, at every given opportunity, whether you're the woman selling tomatoes at the corner of the street, if the police approach you and they start arresting you, the law actually, is very clear how that interaction is supposed to take place. So everyday ordinary people are interacting with the Constitution at all these different levels. And this is why it's very important that the Constitution is seen as a way of life, that the law is seen as a way of life, and that we're interacting with it in everyday circumstances and things. And once we get to that point, it becomes naturally easier for people to be in a position where they can identify the rights that are violated, and for them to actually go out there and demand that there is remedy where their rights have been violated. That being the case, I will just tell you that I've got a story for you at the end, and this particular story is called The People Sitting Under the Tree. So I will talk about it at the very end, but I will talk about all the, the technical nitty-gritties at the beginning of my presentation. So when we read the Constitution, the preamble starts by saying, "We the people." And I think that in itself is a very powerful statement, we the people. So fundamentally, when it says we the people, people, it means that everything that is written in the Constitution, and then it says in the preamble, we the people, it refers to you and it refers to me. So if it says, we the people have agreed to X, Y, Z, but you do not know what's in there, what does that mean? It does not stop what is in that Constitution from applying to you or affecting you, because it says we the people, right? So this is why it is of fundamental importance for us to ensure that people have access to the law. And fundamentally, the supreme law of the land, which is the Constitution, and then we go into all the other laws that feed into the Constitution, that must be aligned to the Constitution. So, a particular section that I've extracted from my presentation in the preamble says, we the people, recognizing the need to entrench democracy, good governance, and the rule of law, reaffirming our commitment to defending fundamental human rights and freedoms. This is our preamble. It really talks about how we the people must do this as a people. That having been said, it's important for us to have a critical reflection on the fact that there are high levels of constitutional illiteracy, and I liked how Bernardo mentioned that across the continent, very young people, and Zimbabwe is no exception. So we know that according to statistics by Zinstats, young people constitute the majority of the population in Zimbabwe, about 67.9% who are under the age of 35. And yet from a research that was done by PACT in 2018, they indicated that in all of their respondents, 50% of them indicated that they'd never heard about the Constitution, and 68% further on went on to say that they'd never heard about Chapter 4, which is the Declaration of Rights. A research that was done by Yates in 2019 indicated that only 1 in 5 young people are aware of the Constitution. That's about 17.5% of young people, of the overall population of young people who are aware of the Constitution in this country. So what that means with those levels of illiteracy of the Constitution, it means that all of these people that do not know about the Constitution and their rights in the Constitution could have their rights violated and not even know that their rights have been violated. It could mean that all of these people who have their rights in the Constitution and have no idea about the Constitution could have their Constitution amended, and they do not have an opportunity to defend it and to inquire and question what is being put in that Constitution. Because as we indicated at the beginning of this presentation was that when it says we the people, it means that what's in that Constitution, we are the people. We have agreed that this is how we will be governed, and it will affect you and me. So those levels of constitutional illiteracy are dangerous. They are unsafe for us as a society, they are unsafe for our democracy, and they are unsafe for the future of young people. So now I just want to talk about what are some of the barriers in terms of the lack of accessibility of law, and not just for young people, but for Zimbabweans in general. We have barriers such as the language and the communication. And I'm very grateful that this particular booklet that has been produced is being produced in different languages. That creates an opportunity for people who might not be very savvy in English and Shona and Ndebele, the major languages, to actually have access to the Constitution in a language and in a way that they can actually understand. Additionally, it comes to the issue of communication. The fact that sometimes most of the communication around the Constitution is lawyerish and is also perceived to be such. Very little has been done towards making it broken down and condensed, masticated in such a manner that everyday ordinary people who might not be a lawyer can actually understand what the Constitution is saying. So the communication around it thereof is very important, and again that connects to the language, taking out all the legal complexities and how the law is delivered to the people. There is also a lack of awareness, and I think I've already touched on that. Those high levels of constitutional illiteracy, it's very alarming and it's very dangerous. And surely there is so much more that we can do as a society to ensure that more and more young people are aware of the Constitution. Moving on, there is a lack of understanding of legal rights. So people just don't understand. Sometimes rights are violated because people do not understand. And some of these things are dependent on those who understand, being in a position where they explain to people what are actually their rights, so that when they are violated, they're able to have the courage to then step up and say, well, I need to seek remedy for this. There are also high legal fees. It's very expensive And fundamentally what that does is that it creates a system whereby there is elitism to access to the law and also access to justice. So those who naturally have more resources have better access to the law and to justice, and those who do not basically are left behind. So we have to have critical conversations around funding and financing, because this also means that a lot of people do not have access to the law and henceforth access to justice. There is also fear of retribution. When sometimes you have recognized that my rights have been violated and you actually want to go out there and say, wait, this is not supposed to happen to me, there is also backlash. And this is sometimes very much common in politically motivated cases, where for you to actually go out and say, I would like this particular remedy for this violation of my rights, there is backlash. There's violence online, and sometimes it's violence that can actually be physical. We also appreciate that another restriction to the law is what we call clawback clauses. So it's basically where you say all this stuff. You have the right to health, you have the right to representation, the right to all this, provided that the argument is, right? Provided that we can afford. And we have seen how a lot of people then do not have access to their rights simply because they are denied on the premise that, well, the government does not have the resources, the ministry does not have a particular budget allocation, and yet it is a right that's there. So we also need to have critical conversations around challenging some of these clauses and their repressive nature. We also have issues to do with corruption. And corruption in itself can restrict access to the law. It could be political corruption, economic corruption, social corruption, political corruption in the sense that, there are instances where it is very clear that this person, according to the Constitution, with Section 61, they are entitled to getting bail. They should get bail. But because of political interference and political corruption, they then do not get it. So it also restricts people's access to justice, their rights violated in the process, and once they are aware, it is very important for us to challenge this. Economic corruption, including bribes, people being promised funds if they give a particular judgment or a particular ruling. All of these things make it very difficult for citizens to access the law, to access justice, and to also ensure that their rights are also preserved. That being said, I wanted just to say that in all of this, context is king, right? Context is king. And if we look at our situation, our context in Zimbabwe since 2017 to present, we have seen that a regression in democratic space and freedoms, civic space and freedoms, again, naturally leads to an increased lack of access to the law for everyday ordinary citizens. We know fully well that came Constitutional Amendment Bill number 1 and the Constitutional Amendment Bill number 2, and fundamentally those bills have been instrumental towards crippling the judiciary. They have been instrumental towards putting in place repressive systems that are then put in place as being constitutional, as being legal. And this then goes on for us to raise questions around the substantive nature of the laws. We have to raise questions around, okay, fine, we have the administrative aspects, but we also have the substantive side, which basically speaks into some laws are draconian. We've got laws that are around accreditation, we've got laws that are around information, the Constitutional Amendment Bill number 2, Constitutional Amendment Bill number 1, the Access to Information and Protection of Privacy Act, and POSA, all of those are draconian pieces of legislation. Would citizens want to actually access those laws? Because if we look at them from a substantive perspective, they do not serve citizens very well. So we have to be in a position where, as citizens, we organize to critically ensure that our country removes draconian pieces of legislation. And this can be done via the Constitution, because all of these pieces of legislation that I've mentioned, if we revert back to the Constitution, a lot of the provisions are not even constitutional. That leads me to my next point, which is alignment. We know fully well that we've got our Constitution and we've got laws, and most of them are not aligned. We have to have critical advocacy and conversation around the alignment of laws to the Constitution, because the lack of alignment between laws and the Constitution is what is fundamentally leading to a lot of people's rights being violated. We know that the Constitution is clear that you have the right to demonstrate. And yet you will be arrested because, well, it's a gathering, because of laws such as high current water. But the Constitution is clear that I have the right to demonstrate. I have the right to petition. So all of these things having been said, it is very important that we begin to also have a lot of advocacy to organize towards the alignment of laws to the Constitution. This will naturally increase access to the Constitution for citizens. It will create interesting conversations amongst different players and actors towards the realization of people's rights. Because at the end of the day, it is about how we as people live our lives, how our rights are respected, and how we can live with dignity, which is enshrined in Section 51, one of my favorite sections of the Constitution. Everything has to be about dignity. The healthcare system has to be about dignity. Transport system has to be about dignity. Water, access to it is really about dignity. So we have to critically reflect on that. Now, because I now have got 15 minutes, I'm going to stop here with all this lawyerish stuff and then talk about the story that I promised you. It's an interesting one. So in my journey as an activist, particularly around the Constitution, I've had the interesting privilege of meeting exciting individuals, some of whom were activists around the Constitution back then before I was even born. And it's been really exciting meeting a particular person by the name of Dr. Wanda Mutasa. Now, he tells a story when they were young once upon a time, in the early 2000s. I must have been a year old or so. He tells a story where he says that they were young, very passionate about the Constitution, and they began to organize themselves around the constitutional process at that particular time. And there was a particular person by the name of Edson Jabor, who told them that, when they had a meeting, we've been seeing you young people going around the country, gathering a few people there, a few people here, and sitting under trees, and you honestly think, and that was how you put it across, you honestly think that if you're a few people under one tree and a few people under another tree, you can make any kind of change, and you can bring these constitutional measures to the fore. And basically, that is what exactly ended up happening. It was a few people under trees who began such a very forceful, such a very powerful movement that also then led to a significant number of processes and events in our constitutional history here in Zimbabwe. So there is a lot of power in a few people sitting under a tree talking about the Constitution. There is a lot of power in a few individuals going up into the space, gathering there and talking about the Constitution. And the fundamental core and substance of this particular story, because it's really a story about accessing the law for citizens. It was citizen initiative, citizens going out to talk to other citizens about the law, about the Constitution. It was about citizens having the courage to say, listen, this is happening, and we have to have a say, because fundamentally, the Constitution says we, the people. It cannot be the decision of a few political elites to define and decide what is actually in the Constitution. All of us must be involved, and all of us must participate. So this is a story that Dr. Mutasa shared with me. I really loved it, and I'm now sharing it with you. So that as we return, we have these critical reflections around how we, in our individual capacities as citizens, are organizing to ensure that everyday ordinary people like you and me also know about the Constitution, also understand the Constitution, and if push comes to shove, are able to rise up and defend the Constitution. So I will end with a few interesting quotes. The first is from Abraham Lincoln. He says, we the people are the rightful masters of both Congress and the courts, and the overthrow of the Constitution. But we must also then overthrow men who pervert the Constitution. I will also go on to the quote from Albert Einstein, who says, the strength of the Constitution lies entirely in the determination of each citizen to defend it. Only if every single citizen feels duty-bound to do this, if only when every citizen feels duty-bound to defend the Constitution shall we secure our constitutional rights. So that is also something from Albert Einstein. In conclusion, this is the last point I promise. Yes, I always say this is my last one. We could have 5 last points, but this is definitely my last one, I promise. So, in conclusion, we have to fundamentally reflect that constitutions are powerful. They're very powerful. And we are living at a time, not only in Zimbabwe, but globally, where we're experiencing a phenomenon where particular regimes, particularly repressive regimes, have realized the power in the Constitution. And they are going after constitutions, they are going after the law, particularly putting in place draconian pieces of legislation during lockdowns and national crises and all of that, and also amending the Constitution. I have absolutely no doubt that in Zimbabwe we could be having more and more and more amendments to the Constitution, more and more introductions of laws. We have the Penal Bill at the moment, once upon a time. The Cybersecurity and Data Protection Act was a bill during the COVID-19 era. And if you just look at the nature of those laws, it is a very clear indication that they have a particular target, they have a particular agenda and intention, and it's really a critical question of asking who has initiated that particular lawmaking process, what are their intentions, and what benefit do these particular laws have for the citizens. So because I'm really going to be very frank with you, there are more laws coming, there are more amendments to the Constitution coming. The only way we can prepare is to ensure that we start sitting on the trees, we start doing those Twitter spaces, alerting citizens, so that when we do pull up on them and say, hey, there's a law that is coming up, the Constitution is being amended, they're in a position to say, we understand what is happening here, and we are going to defend our Constitution. Thank you very much.
Thank you so much. While listening to you, I remember the story back in South Africa during the apartheid era, the story about the tree. During the apartheid era, one of the things that the African National Congress did with artists, they used to gather in Sophia Town and invite your Mamangela Makeba and Kim Masikela and make it look like it's a jazz festival. Meanwhile, it was a gathering of activists figuring out how to end the apartheid government. And I think it's one of the things that I'm personally very passionate about is thinking about creative ways to enhance the promotion of human rights and social justice, right? And I was saying this to Roy yesterday that it's all quite for me because I work in an academic institution and I am so tired of academic language and this high-level language, and part of my writings lately have been around figuring out how to use non-textual tools to teach the law and to teach political theories, or to sit under a tree with ordinary citizens and teach the laws outside of the classroom. There's something very powerful about dialogues. If we aren't talking to each other about what is important for us and the kind of Africa that we want to see, then we are failing us, because I think part of our history in South Africa lies deeply in the fact that activists there during the apartheid era created spaces for dialogue, whether it was in Sophia Town where they made it look like it was just this festival, or maybe even under trees, right? So I think it's important for us to think about ways in which we can dialogue. But also there's something that I said that reminded me of a quote by Professor Charles Fombart, this idea of we the people. And I quote, Professor Fombart says, "A constitution will certainly not serve any useful purpose if the people who essentially brought it to life own it and enjoy the protection of its provision are ignorant of its content." I'm going to read this again. The Constitution will certainly not serve any useful purpose if the people who essentially brought it to life own it and enjoy the protection of its provision are ignorant of its content. And so if we the people are ignorant of the content of the Constitution, then also the truth serves no purpose. I'm going to welcome, before I welcome this person, I want to tell a story. It's not my story. I read a book by Professor Joel Mandu. Professor Mandu was at UCT, and I think he recently left UCT. He wrote a biography on the life of Robert Sobukwe. And anyone that knows me knows that I am obsessed with Robert Sobukwe. So anything that has his name, I read. So Matu tells a story in the book that there was a secret meeting somewhere in the Eastern Cape. This is during the apartheid era. A secret meeting somewhere in the Eastern Cape. And in fact, no, then in that story he tells that when the secret meeting happened in the Eastern Cape, Steve Biko arrived at the meeting a little late, and he didn't want to attract attention, so he sneaked in quietly while the meeting was going on. I mean, if you are Steve Biko, of course you will attract attention. So Biko sneaks in quietly because he's late and he doesn't want to attract attention. And as he walked in the room, he spots Comrade Robert Sobukwe. And again, if you've read Sobukwe's work and have read Biko's work, you know that Sobukwe and Biko had an extraordinary relationship of a mentor and mentee. So when Biko spotted Sobukwe, his attempt to, sneak in quietly, he failed himself, because when he saw Sobukwe, he exclaimed in isiXhosa very loudly and said, "Chini betunana, utiko khona apha." Loosely translated means, "Oh my, you got himself is here." And when I reached out to this person who I'm about to invite to share his reflections with us, part of it was that I want God himself, the God of the human rights space in Zimbabwe himself, to bless us. I tease him and I say he's the Beyonce of the human rights space in Zimbabwe. So please join me as we welcome the Executive Director of Zimbabwe NGO Forum, Dr. Masaki.
Thank you so much, Bonito. I'm no Beyonce. I'm no coach. Well, thank you so much. By now you are all tired of listening to people speak. But I hope you will indulge me for the next few minutes. And then thereafter, I think we are done talking, right? Yeah. Maybe one more person will speak, and then we are done. Thank you so much. Colleagues, let me start by thanking the Center for Human Rights, Lloyd Bonolo, Tarigo and team, for doing this for us. You are our long-standing partner at the Zimbabwe Human Rights NGO Forum, but also to all of us in the human rights space in Zimbabwe. You have been a long-standing partner, and we appreciate that. And I recognize a lot of friends, colleagues, workmates in the room. Thank you so much, and to those who spoke before me, my chairperson at the forum, Deputy Director, Mr. Nyamaloka, Lloyd, former director of the Zimbabwe Human Rights NGO Forum, Namatai, always refreshing listening to you, and my dean at the Faculty of Law, Dr. Mike. Sometimes I masquerade as a lecturer in law school. Right, so why this booklet matters? Why this booklet matters? We are launching a booklet today, a guide to your rights, the Zimbabwean Bill of Rights. It is a booklet that is not only speaking to our Declaration of Human Rights, our Declaration of Rights, Chapter 4, to our Constitution, but it's an explainer to our Constitution, quite holistically. And you will see this when you get the opportunity to go through the book. I had the privilege of reviewing this book when it was being developed. It's quite an explainer to our Constitution holistically. And why does it matter? Why are we discussing a small booklet, simplified, instead of gathering around the hardcore academic treatise written by my friend Dr. John Sabora and others? Why are we gathering over this small? Right. I submit that what we are doing with a booklet such as this, what we are doing, building knowledge for the common man, understanding of the Constitution, is the most important thing that we can do to constitutionalism and for us to sustain constitutionalism and what it means to us. What we are doing today is essentially to put citizens at the center. Right? It's about the people, and we want the citizens, we the people, to understand their constitution. We want them to be able to use it. We are empowered. So to that end, I'm going to share a few reflections this morning, afternoon. I dispelled the notion by Lloyd that I'm going to give an academic treatise, right? Profound academic stuff. That's what he said. I'm not going to say that. Instead, I am going to give a collection of thoughts. You can call them random thoughts. It's your job to connect the dots. So I'm just going to say random things. Right? The first thing that I want to talk about is the issue of the social contract. Right? So the people are the primary stockholders to the Constitution. They are the primary stockholders to the Constitution, which is the social contract. Now, basic logic will tell us that you cannot have primary stockholders to a contract and they do not know or understand the terms of that contract. That's basic logic. Right? If you have people who are party to a contract and they do not understand the terms of that contract, it's easy for them to be done, isn't it? Right? Someone who gets the better end of it, and you will not know. Perhaps you will know, but you won't be able to do anything about it because you are not empowered. You are not tooled to do anything about it. That's basic logic. So you can't have we the people being party to a social contract that they don't understand. It doesn't work, right? That relationship, that contractual relationship doesn't work. The Constitution is exactly like that. It's just a contract. Right? It's a contract of our shared existence. We exist together in these four boundaries that we call Zimbabwe. So we have a social contract, and we are all party to that contract. Imagine if we don't understand what the contract says. You will always be at the receiving end of being duped, of being cheated, of being shortchanged, isn't it? I'll stop there on the issue of the social contract. Now, this booklet is important because it moves beyond providing information on what the Constitution says. Right? It goes on to show in practical terms how the Constitution has been and can be operationalized, including through the courts. I was listening to all the cases that Mr. Yamaroka was mentioning, and I'm glad to say most of those cases are profiled in this booklet. Right? So this booklet goes to actually show in practical terms how to operationalize the Bill of Rights. So we are moving beyond simply assuming that people do not know. Yes, there are knowledge gaps, but let's not simply just assume that people don't know. Beyond knowledge, you want something more. What you actually want is meaningful engagement. You just don't want people to know and then what. Right? What you actually want is meaningful engagement. And this is what this booklet is trying to do. And three things are important here. I want to mention three things. Number one, the people must self-govern. The people must self-govern. As lawyers, we often say the Constitution is supreme. That's correct, but that's not the whole truth. The reality is that the people are supreme. The people are the ultimate supreme. The Constitution is just the supreme law. It's not supreme, it's just the supreme law. The people in their collective are the ultimate supreme. So the people must self-govern, right? And it is the people who determine the social contract, what it means, what the terms are. It's the people who determine the continued existence of that social contract. If the people no longer want that social contract, they can define a new social contract for them, because the people are the ultimate supreme. Right? In the Zimbabwean Constitution, there is something quite unique. You go through the three chapters that speak to separation of powers, checks and balances. Legislative power, executive power, judicial power. They all start by saying, legislative power derives from the people. You go to the next chapter of the executive, all executive power derives from the people. You go to the next chapter on the judiciary, it says all judicial power derives from the people. That's quite unique to the Zimbabwean constitution. Right? As if we the people was not enough. Right? It's to remind us, in case we forget as we are reading the document, that we the people, it's the people. All power derives from the people. The people must self-govern. I won't be mentioning sections, right? I think I mentioned chapters. That's the last time I mentioned that in my talk. You can blow a whistle if you hear me say section. Right? So it is about the people. And if the people are not on the scene, if the people are not included, if the people are not at the center, that's the beginning of the death of constitutionalism. That's the beginning of the death of democracy. Right? Lloyd said constitutional illiteracy is dangerous. Right? In Namatai you say it's unsafe. Right? Those are the words you use. So without the people being constitutionally literate and being able to use this in meaningful engagement, that's dangerous. That's the beginning of the death of constitutionalism. So that's number one, the people must self-govern. Number two, the people must participate. Participation is a running theme through the Constitution. It's a running theme. This Constitution is a product of participation. You remember the 2010 to 2013 COPA process, right? It was about the people. We then went to a referendum, right? And 94.5% of our people voted yes. Right? So the Constitution is a product of participation. And you want that participation to continue, to sustain. It is meaningful participation. Number three, the people must demand. By their nature, human rights must be demanded. They must be claimed by their nature. But most constitutional and human rights advances in history are a product of struggle. Right? You tell me which rights have been given freely and voluntarily. Right? Universal suffrage, one man, one vote, women's rights, racial justice, social equality, you name it. Tell me which right has been given freely. They are all a product of struggle. So the people must demand. Right? Constitutions themselves are a product of struggle. All constitutions, they are a product of struggle. The 1979 Lancaster House Constitution in Zimbabwe was a product of struggle. The 2018 Constitution was a product of struggle. There's a long struggle. Namatai started speaking about some of the stories, right? The genesis of this struggle, right? From the early 90s, right? Until 2018, when we eventually had a new constitution. But the struggle does not end when we get the document. The struggle continues. In fact, it starts when we have that document, because we now want to actualize every single provision, every single right in that document. And how do we do that? We demand. The people must demand. But how do you demand things that you don't know? How do you demand things that you don't know you are entitled to? You can't demand what you don't know, isn't it? So I'll stop there. I was talking about knowledge, just building knowledge versus building meaningful engagement. That's where I mentioned those 3 points. Let me speak now to the promise of the Constitution. I argue that Zimbabwe's Constitution is one of the best on the continent. If you were to ask me, I would say you put the Zimbabwean Constitution there, you put the Kenyan Constitution there, you put the South African Constitution there. Those are the best, in my view, on the continent. I know people have different views, but that's my view, right? But in reality, yes, we have a beautiful document, but in reality, the enjoyment of those rights is nowhere near good, it's nowhere near best, it's nowhere near perfect, right? But this is not just a Zimbabwean story. Even in South Africa, in the way we copy and plagiarize a lot of the Constitution. And it's a beautiful Constitution. It's a beautiful Constitution, but South Africa is the most unequal society on planet Earth. Yet equality is one of the founding values of the South African system and the South African Constitution. I'm mentioning this simply to give an example. To say it's not a Zimbabwean story, to say the Constitution is beautiful, but the reality is far from that. Right? So what does that tell us about the promise of the Constitution versus the reality? What does that tell us? Right? What happens when the promise of the Constitution does not materialize? So we have a Constitution. It's a statement of intent. It's a declaration of aspirations. It's a promise. If that promise doesn't manifest in reality, what happens? So I want to tell you what I heard recently from a man called Professor Karuti Kanyinga. He's at the University of Nairobi. He's the director of the Institute for Development Studies. I heard him sometime last month. He said something along these lines, and I'm paraphrasing. Right? He said we must now stop. Remember, I'm trying to answer the question or probe on the question, what happens when the promise of the Constitution does not deliver? So he said something along these lines. We must now stop assuming things and really start listening to the people. The people in Africa will vote for the rich man or he who has access to resources for them. The people care less about how prosperity, livelihoods, and development come. They just want prosperity, livelihood, and development. In whatever way, in whatever form it comes. The people do not care that the politician is a thief. They will vote for that thief if the thief comes back to share some of his or her needs. So at this stage, the ideals of democracy and human rights are occupying people like you and I. Those of us in the middle class, those in the human rights spaces, those in the university spaces, more than they are occupying the masses. So we might not be moving together with the masses in our discourse. The masses have moved on. That's what he said. Something along those lines. That's scary, isn't it? I reflected a lot on that. And this suggests many things, two of which may be. Possibly, the people are frustrated and they are tired of waiting for the ideal. The ideal that we paint in the Constitution. Perhaps people are tired of waiting for that ideal to manifest. Number two, possibly, it suggests that people are now making practical decisions for their proximate needs, immediate needs, right? And not necessarily based on the ideals of democracy and human rights and the ideals of the Constitution. That's what it might mean, right? So people will take practical decisions, right? Not based on the ideals, perhaps because they are frustrated. Afrobarometer suggests in their data that only 22% of Africans are having discussions to do with governance and constitutionalism and democracy and human rights. Only 22%. That suggests that Africans are disengaging, isn't it? Yeah. It suggests that they are disengaging. The question then is, are people giving up on democracy? Are people giving up on human rights? Are they giving up on constitutionalism? Are they giving up on the promise of good governance? The irony of it is that the answer is no. Again, I'll turn to Afrobarometer data. In their recent survey, they say that 68%, that's 2/3 of Africans, say that they favor democracy as their preferred system of government. 68% say democracy is the best form of government. So it does appear that there is actually a lot of appetite for these ideals which the people are now frustrated of waiting for. The appetite is there. There's an irony, right? The appetite is there, but there is little provision from the supply side. So there is very little provision from the supply side, but the demand is high. That's an irony, and it's a question for us to ponder on. Right? But the task ahead for us, I suggest, is for us to connect the ideals and the proximate needs of the people. In other words, the real manifestation of human rights and the promise of the Constitution is in what people eat every day. They want food. People just want food. They want health care. It's in the schools that their children attend. It's in the jobs that they have. It's in the property that they own. It's in the peace that they enjoy. Ultimately, that's what people want.
Yeah.
Right? They don't care much about what we write in that document, how we write it, etc. What they really care about is the approximate needs. Right? So our job, those of us in this space, is to connect these ideals, which we think and posit are the best for our society, and these proximate needs of the people. That's homework for us. And we have to think deep and long about it. So I'll stop on that point. Right? But this booklet contributes to us connecting those ideals and the proximate needs of the people. That's one reason why I celebrate this booklet. Right? Now, my next point is about the Constitution as a site for struggle. Right? Inherently, a constitution is a site for struggle or a site of struggle. Inherently. Why do I say so? Right? The interpretation of the Constitution is never fixed. It's contested. It's contested, right? The interpretation is contested. That's why we hire lawyers. Lawyers thrive on these contested interpretations. That's how they make money, right? The contours or the outer limits or the boundaries of the Constitution is never fixed. It's never fixed. What we think are the boundaries of that 2018 Constitution today will shift next year. They will shift 10 years from now, and 20 years from now, they will completely shift. So the boundaries are never static, right? They are never static, they are ever changing because new truths are discovered every day. Our realities change every day, right? That's why we call these documents living documents, right? So anything living, any document living is a site of struggle. It's a site of contestation because we are contesting the meaning all the time, right? We are seeking to push the limits all the time. Right? But the Constitution is a site of struggle also because there is an inherent power struggle between the governors and the governed. It's in this Constitution that we give power to those who govern us, right? And governors, because they have power, it's the nature of power, they always want to test the limits, the outer limits of their power. And us, the governed, are always trying to limit, right, the extent of their exercise of that power or what that power means. So the Constitution is an inherent site of power struggle, right? Why does this matter? Imagine participating in that struggle and you are not empowered. You don't know what this document says. You don't know what you are capable of doing or what you must do. Imagine you will always be on the losing end, isn't it? You will always be on the losing end. In law, we say the law protects the vigilant. The law protects the vigilant. It's only those who are vigilant who derive the benefit of the protection of the law. That's the practical reality. Like the ideal is we don't want that, but the practical reality is that is what happens. And then in social science, we say eternal vigilance is the price for liberty. Right? Eternal vigilance is the price for freedom. If you want freedom, you have to be eternally vigilant. Right? So, I'm simply trying to explain why it's so important for us to know the Constitution, for our people, for the people, the ordinary people, to know the Constitution. And at the end of the day, the truth is that the Constitution is not self-executing. It's just a document. It's just a piece of paper. And it's what we do that matters. Right? It's what we do that matters. Now, if I were to pick what I would consider to be the most important aspect of constitutionalism, it has to be that constitutions and constitutionalism are culture, or about a culture, or a culture. And Namatai painted that very well before me. Right? If I were to pick what's most important about constitutions and constitutionalism, it's culture. That's the word. It's culture. Right? There have been studies in the past that societies with unwritten constitutions, we all know there are countries without written constitutions, right? There have been studies to the effect that societies with unwritten constitutions actually fare much better compared to societies with written constitutions in terms of constitutionalism. What does that mean? It's not about the document, it's about the culture, right? Yes, the text is important. Yes, the text creates institutions for us, and institutions are vitally important, but it is the culture that accompanies that institutional architecture that matters the most. It's the culture that matters the most. Take, for instance, in Zimbabwe, the founding values in Zimbabwe, right? Section 3, thereabout. There I go mention sections. We have founding values in the Constitution. And rule of law is one of those founding values. Rule of law is one of those founding values. But here is the thing. The rule of law itself is not dependent on any positive law or positivist law. Positivist law, this written law. The rule of law itself is not dependent on that written law or what we call positivist law, right? And although it may be couched in those positivist terms, it essentially consists of values. Rule of law is all about values, right? It's all about values. And what is equally true is that even in a country like Zimbabwe, where you have a justiciable declaration of rights or a declaration of rights that you can take to court and argue and claim certain rights, right? The rule of law can actually be undermined. You have a constitution which says rule of law is one of the values. You have a justiciable declaration of rights, but the rule of law can actually be undermined in that society. How and why? It's because of values. It's because of culture. If our culture is such that we really don't care much about what this document says, we will always be undermining that constitution. We will always undermine those institutions which we have crafted. We have a lot of beautiful institutions in Zimbabwe, which is why I say our constitution is one of the best, because the institutional architecture is quite solid, right? If you compare to other societies, it's quite solid. Yeah. But if we have an appetite to undermine that because we don't have a culture of constitutionalism and respect of rule of law, we all know what happens. Yeah. We don't have to explain that to Zimbabweans, isn't it? Right, so the point is simply what Bonodo mentioned, right? Having a constitution does not necessarily imply constitutionalism. It's more than that. The constitution is just but a document. I'll end by simply saying I can't and we can't stress enough the importance of this publication and what we are doing in terms of building constitutional awareness and literacy and ensuring that our people are at the center. We can never stress that enough. It's about the people. When we wrote this constitution, our Zimbabwean constitution in 2013, we anticipated the need for people to be at the center and for people to be meaningfully engaged. How? Right? There is a clause there in the Constitution which requires, number one, that this Constitution should be translated in all 16 official languages in Zimbabwe. 16, we have 16, right? We beat the South Africans. We have 16 official languages in Zimbabwe, including sign language. Yes. Interesting. This Constitution must be translated in those languages and it must be disseminated. It's there in Section 7 of the Constitution. It says that Constitution must be taught in schools as part of the academic curriculum. It's there in Section 7 of the Constitution. It says that Constitution must be taught to security services. It should be part of their curriculum. It's there in Section 7. Or you're blowing the whistle. Okay. Section 7. It says that clause. It says in the curriculum for the training of civil service, and anyone affiliated to any governmental service or office or department, it must be there in the curriculum of their training. It says in that clause, all people and organizations, including civic organizations, because the Constitution doesn't recognize CSOs, it does. Right? It mentions in that clause that all organizations, including civic organizations, civil society organizations, must spread this constitution, must spread awareness. It's there in the constitution. So what we are doing is we are fulfilling our Section 7 mandate.
Exactly.
Right?
Precisely.
We are fulfilling our mandate in terms of the constitution. We have a constitutional mandate and we are fulfilling that.
Exactly.
So I'm going to end there and thank you all for participating and thank you all for listening. Thank you.
Thank you so much. Yeah, a few things. But I think when Dr. Musa was talking about connecting ideals of democratic ideals to the needs of the people, it reminded me of the conversation I had with my mother. I tell the story all the time. I'm sure Ray has said it more than 7 times. At the moment in South Africa, our local governments are governed by coalition governments after the 2016 local government elections and the 2019 local government elections. So I was having a conversation with my mother about some of my work that looks at, coalition government in South Africa. My mom was quite cheeky. She said to me, "I don't care about who governs the municipality. It's not water." She was like, "I just want clean water." And that's that, right? I think prioritizing and thinking about the needs of our people is that important. So thank you for those reflections, Dr. Musa. We are going to, I'm sure you're tired of listening to people talk. I want to leave the IT guys are ready. Are you ready to say? So one of our partners have produced this brilliant documentary that looks at the journey to justice. And part of that is really making the Constitution accessible to citizens. So I want us to take a little break and watch the documentary. And then right after the documentary, what we're going to do, I remember one of the critiques I gave to President Cyril Ramaphosa during COVID-19 was that he was talking to us and not with us. So after every 2 weeks or so, the president will come and address us and just won't even create space for the media to engage with him. And I just really think that that's very concerning. So what we want to do is to have a conversation with you about what we've been talking about, as opposed to us talking to you without you talking to us and without us talking with each other. So we'll have a look at the documentary, and right after the documentary, I'm going to ask Lloyd and Dr. Musa and Melvis, I think, to come join us here, and we'll take questions from the audience, and we'll just have a conversation. Thank you. Maybe we should turn off the lights.
Journey to justice.
To know one's strength. Often, it is an adventure, especially when the opponent seems to
Can achieve. So we have taken the perspective of these people and we will now tell you their story.
Remember, the law almost always gives you the necessary tools.
And this is exactly what is shown by the two cases that he presented. Our journey to justice leads us to the Kenyan coast.
And up to the northwest of Kenya.
Lake Turkana is the largest desert lake in the world in the UNESCO World Heritage Site.
According to historians, the area around Lake Turkana is considered to be the cradle of mankind. Excavations show that Homo erectus lived here around 500,000 years ago.
Cattle keeping, but mainly fishing from Lake Turkana, has been the source of livelihood for the people around here from the very beginning. Even today, the communities around Lake Turkana largely rely on the lake as the source of livelihood.
In the year 2006, a tunnel cycle between nature and man was started in
The fishermen around Lake Turkana started noticing decreasing water level and a dwindling number of their catches despite increased fishing levels. This is what fisherman Fimo remembers.
Hivi karibuni tumeelewa sasa ujio na mengine tunaenda tena mbali ndio upate samaki. Tumeelewa samaki sasa hakuna. Ile na vipi? Ile wajue na vipi mzao mnapata na uwezo wa kutafuta ile samaki mbali. Hata kwa hapa tunataka kumsaidia sita hivi sio wanapata upendeleo. Na walikuwa wakutegemea wao pia.
Francis Essien Nankomo, then chief of Loremas, reviewed us.
The failure for one is the leg is the mega source of Peter. Most of the villagers associated the bride of the leg to Ghana to ancestral caste. The community gathered, they talked, and they came to a solution. They have to do some rituals, their ancestors. There is what I know, but this never changed.
At the same time, Ikal Angini, a young social worker in Turkana at the time, also had the rumors.
We just heard from fisher folk indicating that there was something big that was being constructed on the Omo River.
She could not share the beliefs of the community that they were cast by their ancestors, so she began to research on her own.
From those conversations, we decided to discuss with the same fisher folk, the communities around the lake, and the politicians representing the region. We then started to engage the communities about what they wanted to do and how we were going to come together and fight against the construction of the Kibefti Dam, which was one of many other dams that was being built along the Omo River.
The government of Ethiopia endorsed the construction of the Gibe 3 hydroelectric dam on River Omo to generate power and regulate the flood water reserves.
The dam would be about 250 meters high and 600 meters long. The government of Kenya entered into a power purchase agreement with the government of Ethiopia in 2006.
Concern was confirmed that the construction of the dam project will severely affect Lake Turkana.
Communities of Koronya, Kalokot, Kanamkuru, Loharena, Nachukui, and Katabo all came to Kalokot to advocate on matters concerning the lake because this was their major source of livelihood.
Ilikuwa inasaidia country ngapi? Sudan, Ethiopia, Kenya.
Over time, the advocacy was not only national, it was global. And through that engagement, it was clear that the local communities did not know what had happened, they did not give any consent.
Misikal and Yele convened the meeting at Kalokol with the help of the local leadership.
At the meeting, the local Turkana community signed a memorandum allowing Ikal Angini to go lodge a complaint at the High Court on their behalf. With the signed petition, Ms. Ikal Angini visited the advocate, Mr. Walter Amoko, for the first time.
Sometime in 2010, Ika Ngele contacted me in respect to concerns that she had developed and had in respect to what was going on around the Turkana, and in particular the cascade of dams known as Gibe 1 to 5 that the government of Ethiopia had undertaken to construct along the River Omo. The principal one was the Gibe 3 dam, which was then in the course of the construction. And it was also of concern that the Kenyan government was cutting some deals of one kind or another whose details were not in the public domain for the purchase of electric power from the people. I did my own research, and it was clear to me that the government was more or less failing the people of Kenya, especially the local communities which were within the vicinity of the Turkana and relied on it for its activities. In one form or another, the Kenyan government has committed itself to the purchase of electric power, even though it does not seem as if any agreement has been signed, but there was a memorandum of understanding. Because as I understood it, without a commitment from the Kenyan government for the purchase of electric power, the Gibe 3 project would not be viable or would face serious commercial challenges. It was making representations that the Ethiopian government had not done enough to mitigate those adverse effects. We had clear representations made on behalf of the government of Kenya by the National Museum of Kenya to the World Heritage Committee of UNESCO that the Ethiopian government had failed to take enough steps and should take enough steps. Out of a sense of frustration and anger as to what the Kenyan government was doing to its citizens, who are the minority communities within the Turkana region, I agreed to take the case pro bono on behalf of the community.
In 2012, hearings started at the Environment and Land Court, which is a specialized division equal to the High Court.
Walter Amoko decided to pursue the following: right of access to information held by any public body under Article 35(1)(a) of the Constitution of Kenya 2010.
This means the duty of full disclosure of any potentially affected person or community while pursuing a project that may impact the exercise of their rights.
Breach of environmental and cultural rights under Article 42(a) and 44 of the Kenyan Constitution.
Breach of public trust with failure to preserve and protect the environment as stipulated by Articles 62 and 69 of the Constitution of Kenya.
It was not clear who was spearheading the project or arrangement with the government of Ethiopia, whether it was State House itself, Ministry of Foreign Affairs, Ministry of Energy. After being able to know which of this, we decided to sue the Attorney General as representing the government of Kenya, and also the Kenya Power and Lighting Company Limited, as it was then known, because no purchasing power agreement would be entered without them. The other obstacle we faced, which was with respect to the nature of the case, is it involved foreign affairs. These were arrangements between the government of Ethiopia and the government of Kenya. When it comes to foreign affairs, the country should speak with one voice, and that voice should come from the executive. So it was necessary for us to make it absolutely clear that the nature of the inquiry we were asking the court to undertake would not intrude into that delicate balance between its role and its respect for the foreign affairs being conducted by the government of Kenya. And I think for the most part we succeeded in doing that.
2 years later, in 2014, the Environment and Land Court delivered judgment.
These were the most important findings of the court. That the government of Kenya failed to meet its public trusteeship role to the environment as enshrined under Article 62 and 69 of the Constitution.
The government of Kenya also failed to conduct a full, proper, and thorough comprehensive impact assessment on the potential effects of constructing and operating the Gibe 3 dam before committing to the purchase of power.
In case you're wondering what an environmental and social impact assessment is.
An environmental and social impact assessment and a strategic environmental assessment examines the impact of a project on the environment and the social well-being of the people.
This then informs stakeholders and decision makers on how to safeguard the environment and the social well-being of the people. Additionally, the court found that the project and its impact assessment was shrouded in secrecy, thus failing to account for the right of access to information.
According to the court, it would have been the government's duty to involve citizens in the whole process by providing information about the project and about their rights, as well as giving them an opportunity to air their views on how the project will be run.
It is important to mention that the case went into appeal and is therefore still pending.
In order to give you a better idea of the importance of this judgment, we had the unique opportunity of speaking with Honorable Chief Justice Emeritus David Maraga, Chief Justice of the Republic of Kenya from 2016 to 2021.
Under the old constitution, there was no provision for public interest litigation. Public interest litigation was only limited to suing for the rights of dead people. Considering the history of Kenya and the development of its institutions, the Turkana case is important for three reasons. One, it demonstrates that after years of weakness, Kenya is now a strong democracy with an independent judiciary. Secondly, it also shows that if they take the right steps, even ordinary people can get the government and giant institutions like the power companies not to ignore their rights. Thirdly, it demonstrates that the 2010 Kenya Constitution is an excellent tool in providing for access to justice.
Turkana was just a starting point.
A marginalized community came to the public eye.
Turkana has paved the way for further cases of a similar nature.
We want to present an equally important case on our second journey to justice.
Our journey takes us to Lamu.
Lamu is situated along Kenya's northern coastline.
Lamu County comprises Lamu mainland and 4 islands: Lamu, Manda, Pate, and Kiwaju.
Lamu, which boasts as one of the oldest cultural sites in Kenya, dating back to the 14th century, is also designated as a UNESCO World Heritage Site.
The community has always benefited from the complex marine ecosystem.
The great abundance of fish in the shallow waters around the island can also be attributed to the following: to healthy, extensive coral reefs and purifying mangrove forests along the edgeline of the coast.
Lamu's complex marine ecosystem and the island's unique architecture, which looks like something out of an Arabian Nights fairy tale.
The calm and serenity of the islanders.
All of this has attracted regular high-quality tourism in recent decades, which has been well integrated into Muslim society and has given residents more income and stability.
However, in 2011, unrest arose in Paradise.
Mradi huu uliingia kwa kishindo maeneo yetu ya Lamu bila sisi wenyewe kujulishwa.
Asasi za serikali walikuja wanataka kuchimba ili kuongeza kiini cha maji ili meli kubwa ziweze kuingia.
Kutumia matrakta, wakitumia magari ya nguvu kuja kujenga maeneo na makaazi ya watu sehemu za Kigilana, mabuni kubwa bahari ya Manda Bay.
Kulikuwa na matumbawe eneo hilo ambao tunategemea kama ni breeding area. Vile vile kuna uvuvi wa lobster, kwa hivyo hilo liliweza kuharibiwa. Pia vile vile maji yalichefuka.
Hatua kama hiyo serikali iliyochukua pamoja na wawekezaji ilihangaisha watu sana.
This was just the beginning.
In 2009, the government of Kenya came up with the LAPSET project, which stands for Lamu Port, South Sudan, Ethiopia Transport Corridor.
LAPSET consists of 7 infrastructural projects.
A 32 bulk port at Lamu,
Interregional standard gauge rail lines,
interregional highways,
A crude oil pipeline, a product oil pipeline,
international airports,
and resort sites.
the Lamu community heavily depends on the environment for at least 80% of the economic activities.
Wakati wa nyuma kabla uundaji haujaanza pia kuchafua haya mazingira, mapato ambayo siko tukipata na mapato ya sasa, utaona kuna tofauti kubwa sana, kwa sababu zamani hali hapo tukienda kuvua na pengine kwa siku tukiweza kupata kilo 100, kilo 200, lakini sasa hii unaona unang'ang'ana pengine siku 2 ama siku 3, na vile vile pia usiweze kufikisha hata kilo 100, pengine umefikisha kilo 20.
Mohammed Akman from Trade Lamu and other civil rights groups started to closely communicate with the community.
Tukawaita wadau wote, wakulima, wavuvi, wenye mikoko, wavunaji mikoko wale, na wenye biashara mbalimbali na watumiaji bahari, kukaa chini kuzungumza haya mambo ambayo yamejitokeza, na sisi kama wakaaji wa Lamu tufanye nini ili haki zetu zisikanyagiwe. Jambo la kwanza tukaona kuanza ya serikali kupata kujua kiini hasa kwa yale ambayo yanatendeka, kama vile idara ya uvuvi, idara ya mazingira, idara ya ardhi, idara ya kilimo, idara ya ufugaji, lakini pakubwa habari kamilifu hakuzipata, na serikali kabali inaendelea na shughuli zake za kuvunja mashamba yetu, kuvunja makao yetu na kuharibu mikoko na kuchafua mazingira ili kuweka mradi mbalimbali.
The general strategy was to go to the stakeholders as opposed to calling them to come to them.
In the case of private and government businesses, they visited their offices, attended their meetings, and used social media.
When meeting the stakeholders, the following worries were raised.
They were worried about potential harm caused to the marine ecosystem,
mangrove forest destruction,
industrial discharge,
And reduction of fish species.
they were afraid of
negative effects on Lamu's cultural heritage,
air pollution effects,
lack of compensation for land under the source of livelihood would be destroyed.
they were worried that
breeding ground for fish will be destroyed.
Sand from dredging will travel far in the ocean and will affect fishing grounds and crab habitats.
coral reefs will be affected by the sand dune.
homes will be destroyed.
They were worried that boat owners, boat operators, fisherfolk, and others dependent on tourism would be affected.
Katiba Institute, a human rights advocacy NGO, took interest in the matter, following several efforts to raise attention for the worries of the community regarding the LAPSET projects.
In 2012,
They took up the case and presented it in court.
This was just 2 years after the passing of the 2010 Constitution. So this case was going to test the breadth and scope of the application of the right to a clean and healthy environment and the right to livelihoods and actually the right to culture. It was filed in the High Court in Malindi, then it was moved to the High Court in Mombasa, and finally to a 5-judge bench at the High Court in Nairobi.
Advocate Mr. Weko Wanyuze, the then Executive Director of Katiba Institute, together with Ms. Christine Konge and Mr. Lempasu Yanka, as the Assistant Advocate, took responsibility for the petition report.
The community has been seeking information about the project For here, this project was initially conceptualized in 1973, but never came to fruition until 2000, early 2000. Even when the community support information did not get information, and the government was manipulating the process, including the process of speaking information from the community. The general lack of transparency and accountability in the part of the government, including how much the government was spending, whether the project has gone through the requisite environmental law requirements, including the environmental impact assessment, but also strategic environmental assessment, which is bigger than environmental impact assessment.
The strategies that we employed was actually involving different actors so that at least they help the court and ourselves to understand the petition and present it in the best way possible. So we engage international witnesses who actually came to court and gave enough evidence on the matter, on the conceptualization and the implementation of the project.
In 2018, the main hearing of the case under the name Muhammad Ali Bani and Aris versus Attorney General and 11 others started at Nairobi High Court.
The hearing of the case took place in 6 days, where both the petitioners and respondents presented their witnesses.
In the judgment, participating as the respondents were
the Attorney General representing the Ministry of Transport,
the implementing agency, the KPA, Kenya Port Authority.
An important thing happened during the hearing.
With support from Katiba Institute, National Justice, and Environmental Advocacy NGO brought in expert witnesses from both local and international level to demonstrate the actual negative effects of the project on the environment and the community at large.
We brought 3 experts who were vital in 3 aspects of the case. The first expert we brought is called Annie. He's an economist with vast experience. He was able to speak in regards to the external costs of the Lamu Port project. The second expert that we brought on board was called Mark Shenek. And Mark has a vast of experience in reviewing the environmental impact assessment reports. He was able to give an opinion on the deficiencies in the environmental impact assessment report, looking at the positive and negative environmental impacts that have been outlined, the mitigation measures that have been set out to address the negative impacts, and to really show how inadequate we were. We had experts that was brought on board with an agriculturalist called Dr. Buda, and Dr. Buda was able to speak to the impacts of the Lamu Port project to the marine environment. So looking at the impact of the marine ecosystem and the coral reef, and really showing the impact of the port project and how it controls to that environment.
After hearing the lawyers and experts, the judges decided to make a site visit to Lamu to see for themselves the controversies raised in court, which helped the court understand the extent of the project and the effect on the environment.
Another important issue before the court was that Save Lamu and Katiba Institute received the support of the county government of Lamu as an interested party.
They were supporting the plea of the people of Lamu.
The county government was very clear that it was never involved in the conceptualization of the project. We found it very, very important for one of the government or one of the government at least to break away from the NEMA National Renewable Activity and Kenya Ports Authority to realize that public participation is one of the national values and principles under Article 10. And indeed, having done that, the court was very keen to know why the national government would implement a project of such a magnitude without involving the county government.
The community system of private policy a grant to see the impact that the community was talking about, whether it's the impact on mangrove, whether it's the impact on fishing stock, whether it's the impact on their fishing landing site. The community always made an effort through their own resources to make sure they were represented in court, not just because they were certified, but to be able to participate in the proceedings. Being one of the states, I would say, represent the best arrangement when it comes to public investigation, especially community-driven public investigation.
Afternoon, everyone. So, in the interest of time, I have paused the documentary. Sorry, I used my executive powers not provided with the Constitution. So, I will send, as with the booklets, I will send the link to the documentary, and then you can watch the rest. It's about 10 minutes, but I also know it's almost lunchtime, so I'm thinking of all the levels that we need to protect this afternoon. So as Bonolo said, we will now go into a question and answer session. We'll open it up to the audience first, and then I'll invite Lloyd, Dr. Musa, and Mavis to also come up and give some reflections, questions from the audience, or any other questions that may arise. So I've opened it up to the audience. We have a mic here. I don't know if someone can help me to take it around, but if there are any questions from the audience, the floor is yours now.
We are now really, creating this awareness of the need to also infuse issues of language as we promote human rights, because in my own understanding, these are issues that should form a constitutive foundation for the enjoyment inside of our human rights. And let me commend, the Federal Organization for translating this manual into these two local languages, but to also ask Phil, that can it also be extended to all the other officially recognized languages, especially for the ethnic minority groups and persons with disabilities, because for me, these are the most vulnerable groups in our society. You find that the Venezuelan speakers have been advantage because if you look at their interest levels, even in the English language, they fare better than those from ethnic minority groups and persons with disabilities. And then the other issue that is of interest to me, as we talk about interest, I think we also need to be aware of the fact that not everyone can read and write. So as we try and promote constitutional interest, let's also explore other media, mainly the use of radio, for example, where people can just listen and learn about that. Let's have dedicated programs that create awareness and learning about the Constitution through such platforms, because the majority of our people cannot read and write, and also even the poor culture of reading in our society. Let's look for other ways of really entrenching this culture of constitutionalism, where people get that awareness through listening to radio programs as well, that can help them learn about the Constitution.
My question is in relation to the issue raised in relation to and citizen participation within constitutional processes. You know, on the background that Zimbabwe is seen institution of statutory instruments that have repealed previous statutes within the previous act, including like the PVO bill, media practitioners bill, the cyber security and the cyber security act. I believe these acts, in essence, have actually gone further steps in terms of masking the freedoms within the media space and the voluntary organization space. In this regard, can you safely say that this 2013 constitution has been a leeway towards the annexation of human freedoms for the Zimbabweans in general? And then my second issue was in relation to indigenous people's rights. Globally, I think the United Nations Habitat, Center for Habitats, centralized the concept of indigenous people's rights. Another background that Zimbabwe is currently on an economic development trajectory that is seen to the establishment of vast industrial, agricultural projects, that have sought to displace citizens who have been occupying those places so that this economic development can be implemented. What are the technical issues following this? Because from my understanding, the United Nations Habitats Department strictly says that the indigenous people rights precedes any other development that could take place. And in the background of the Chilonga development and other issues that constantly come up because of the anticipated economic development. What are your professional and from the legal perspective as to how can we maneuver around this balance of economic development and indigenous people's rights?
For that, we'll take, I think, two more and then we'll give the panelists an opportunity to respond.
Afternoon. I have a contribution and maybe a question. So we are saying with the people, when I walked in here, I noticed that, sorry, but in here we are all gatekeepers. And we want to take this literacy booklet out there. I mean, where are the CBOs? Where are the chiefs? Because I have met almost 3/4 of everyone in here in a launch like this. Are we launching it for ourselves? Because I am quite sure everyone who's in here is quite literate and quite articulate with the Constitution. Like, where are the people that we are going to give this to? And in reference with that, if we look at the booklet, we have actually used the visualization, imagination. We've used the people that this booklet is going to be used, but we've excluded them in this launch. Like, where are the people? How are we going to take this out there? Thank you.
Okay, these last two. We'll get the panelists respond.
Thank you. Well, my question is based on the fact that, the power to make legitimate laws or to legislate lies on parliament. And politically, the party that occupies 2/3 majority of seats in parliament has the power to make laws. And in the case of authoritarian regimes like Zambia or Zimbabwe itself, we then have what they call administered structural tyranny. So I want to know how best, in the best interest of the public, can we escape structural tyranny, especially in terms of promoting and ensuring that the Constitution is followed?
Thank you. My question is, I would direct it to Mr. Korea and Musa. So we assume that the judiciary itself, I know they'll try to read this book, they'll try to get the meaning from this little booklet, but we have too much assumptions that they know the Constitution, they know the interpretation of the constitutional rights and everything. They are the best placed to give effect to the Constitution. Which assumption I want to deny? Is there scope for the partnership of institutions that are here to consider funding a hardcore smackdown book on constitutional rights or on the Bill of Rights? Thank you.
I think we'll close this first round of questions and hand it over to the panelists to respond.
I think you should give them the mic. Do you still have it?
Thank you very much. I'm going to leave a lot of the legal aspects of the questions to my two colleagues and look more into the civic engagement questions that have been raised around how we have been able to maybe integrate the minority groups with the production of materials that are mostly, I can say, elitist, that is probably just shown in English and perhaps does not also include the PWDs and other minority groups. And I guess there has been efforts towards this, but the major challenge remains the funding aspect of it. Because as we can see that in terms of trying to produce perhaps maybe braille text or having sign language interpreters in some of the materials that we produce, it remains really a funding issue. But I think with most organizations that have been having campaigns around constitutional awareness, there have been efforts to also get the incorporation of organizations such as the disability awareness organizations to be part of these campaigns so that we can have holistic campaigns that include those groups as well. And then in terms of the awareness programs and efforts to also then engage on platforms that are not only these sort of elitist platforms, I can also speak on behalf of ourselves as civic engagement organizations that, especially during the COVID era, there were a lot of radio programs around constitutional awareness. And we can speak to the fact that there was an increase in listenership around these programs because I can say we ran for around 6 months to 7 months, and there were a lot of engagement with even the ministry itself coming to us and saying that there has been an increase in requests for copies of the Constitution, which the ministry itself has not been able to even supply the constitutions. So personally, I believe that it is good that more organizations are coming up with toolkits that are more user-friendly. As you might note, the Constitution itself is not user-friendly in terms of the languages and the text. More simplified materials are also very important. So I think platforms like this and engaging with organizations that are able to simplify text for the ordinary citizen has been a plus. And then if I can also then speak to the issue that has been raised by my colleagues around constitutionalism being a culture. I would also add that culture is a mindset. And how do we develop mindsets? As we have noticed that there's been the issue that sometimes we find the very poor and the elite are not interested in these issues. It's the middle class, like ourselves, who are pushing the agenda of constitutionalism. So it comes back to the fact that we really need to start at a lower level civic engagement to raise civic awareness and civic issues to young people. And when I say young people, I'm not talking about the teenagers. Perhaps as young as early as ECD, as primary school, have there been those efforts? And I know in our context, we have tried to engage MOPSEC, the Ministry of Primary and Secondary Education. And I can say that whether unwilling or unable, but we have also then tried to have platforms within the communities where young people can start clubs. And we have made strides personally as an organization to have maybe essay competitions where children can then start engaging, giving them incentives to talk about constitutionalism, to write up, to go and find out about the Constitution and write about what they think. And engagement at that level helps to build the culture. So I've been speaking in terms of the civic engagement aspect of the questions that have been raised, and I'll leave the legal ones to my colleagues to respond to. Thank you.
Another mic, maybe. maybe I'll take the mic to the spot and then Lloyd to get that. Sure. Okay. So I like the question about where are the people. That's a very important aspect, right? Because many here already know, right, about the Constitution. We might not know everything, but most of us know something, at least the basics. But the good thing about many organizations represented here is that they have constituencies. And it's those constituencies, where we want to take the message, right? It's more like a training of trainers. Or you have your core, which you want to sensitize, and you want them to understand what we want to do. And then you want us to go back to our universities, to our organizations, to our communities, to amplify the message. So this is really what we are trying to do. Even if we were to bring people here, we are not going to be able to fit everyone that we want to receive this message. So it's about the amplifier effect after this exercise. The second speaker, you were asking about restrictive legislation and statutory instruments and acts of parliament catching back on the Constitution. You know, there is this phrase which says constitutions are made by the people against politicians. And then legislation is made by politicians against the people. Right? That is what happens in practice. Right? So we have the Constitution as the gold standard. And then you have those with legislative power or executive power, then passing certain laws to claw back. Matai spoke about clawing back earlier. Right? Statutory instruments are a big problem in Zimbabwe. This is an issue that has been spoken about quite sufficiently. It has been written about. For the most part, it amounts to go by decree, executive decree, because statutory instruments are not made by parliament, they are made by the executive, right? So statutory instruments are easier, they are faster, they are cheaper, they are not contentious because it's just one person sitting in a minister or this writing instead of something debated in parliament. So usually, repressive societies love statutory instruments. It's go by decree. It's not a practice that should be encouraged. Yes, even in other developed societies, there's a lot of regulations and statutory instruments, but those are not to be encouraged. I think my brother Roy will respond to the indigenous rights issue. I think I saw you researching. But there has been a lot of recognition from UN level to AU level on indigenous people's rights. Right? There are now standards that must be followed in terms of economic development that affects indigenous people. Unfortunately, you also get political and economic interests shaping things, right? You get economic corruption, you get political corruption, you get ignoring the rule of law, as we were speaking of earlier. Unfortunately, that happens. Dr. Sabora, I think that question is directed more to Mr. Kubert. But it's important to have a text, right, that can be used by judges, by magistrates, by prosecutors, by people within the commissions, constitutional commissions, and they must be a solid text on understanding the Bill of Rights, right? So that will be written for a different audience, but even the common person can also read and learn something out of that. We don't have enough literature in Zimbabwe. We don't write enough. Perhaps it's an issue of resources, perhaps it's an issue of us needing to excite interest. But of concern is that actually now, 9 years into the new constitution, we don't have any meaningful declaration of rights textbook in Zimbabwe. That's why it's I'll stop.
Alright, so this mic is now, the Robbie mic is now working. Next time I'm not going to share the podium or panel with my brother Musa, because he knows me so well. He saw that I was researching on indigenous people's rights. I don't know how he saw that. But anyway, so thank you very much. I'll just respond to that. I'll start with that question. It's very interesting. I'm saying that because the Center for Human Rights currently, actually last week, it was running a short course on human rights, on indigenous people's rights. And we looked at indigenous peoples across the continent, how their rights have been affected. Okay, we're talking, for instance, of the Maasai in Tanzania, who are being evicted because of government's idea of developing this wildlife conservancy in partnership with international investors. Okay, and the same applies with the issue of the Okiek community in Kenya, whose forests were taken by the government for development projects, and they were evicted from their lands. What is interesting is that they went to the courts. Eventually, they reached the Continental Court, the African Court of Women and People's Rights, and in June, the African Court came up with a decision whereby they ordered the Kenyan government to compensate the Okiek indigenous community close to $1.5 billion. And they've also ordered them to make further compensation for how to their cultural life and other interests in that land. Because as you know, indigenous communities are intricately linked to the land for them and the environment. Their livelihoods is actually based on the environment or the land. Now, to bring it closer home, I think when I was looking here, and which is why I was researching, we've got the Roma people. I don't know how many of us know about the plight of the Roma people in Zimbabwe, whose land was seized by the government to establish the Cheora National Park and Lande Safari area. So, I don't know, life is so ironic. I've always thought about the ironies of life. Have you noticed how, for instance, where you find indigenous communities, there is a lot of wealth there. There is a lot of land there. And then the government will just decide, let's just remove these ignorant, uneducated people and put up these development projects to make more money. And I think where it's the Chilonga and Chirezi, again with the Lucerne development project. So why am I bringing all these issues? I'm just trying to sort of contextualize and say that these are the challenges that we face. But now when you look at the Constitution of Zimbabwe, it looks at the issue of environmental rights, isn't it? So because as I said, the issue of the environment is very intricately linked with the interests of indigenous people because they literally live on their surroundings, whether it's a forest, whether it's land, whether it's a river, and so on and so forth. So you cannot again arbitrarily evict indigenous people because of a development project. And when you look at our constitution again, there's a provision that proscribes the arbitrary eviction of people without informed prior consent, without consultation, without meaningful consultation, without providing alternative land, for those people who are affected. So again, indigenous people are an example of marginalized people, vulnerable people who need the protection of our constitution, and that is important. Then the issue of, I think from Dr. Savora, I agree with my brother here, Dr. Kita, that, definitely we cannot make assumptions that our judiciary know everything about, the Bill of Rights. And I think it is important that lawyers in Zimbabwe develop further a culture of public interest litigation. And I think Blessing spoke about the work that has been done by Zimbabwe Lawyers for Human Rights, and I think the forum as well in terms of public interest litigation. And I think, I know the Zimbabwe Law Society is represented here, to call upon lawyers in Zimbabwe to, dedicate a portion of their time to do pro bono litigation, not always for money, but to assist the most vulnerable, of members of our community and our society. So that they take these cases using the Constitution, they take them to the judiciary, and really do a lot of research. And there's a lot of jurisprudence, from other countries. There's also the international human rights law that Zimbabwe has signed up to. And so lawyers can use those norms to then do public interest litigation and develop further our Constitution and help the judges to interpret this Constitution in the context of international human rights norms, and also jurisprudence from elsewhere that is applicable to our jurisdiction. So I think that is important. And I think in terms of a book, I think that should be the next step. Actually, coming up with a book, we then need to talk some development partners. I don't know if they're still here. We can talk to development partners to fund the drafting of another book that targets members of the judiciary, law enforcement officers, and so on and so forth, so that we complete the whole process. We're not just looking at the rights holders, but we're also looking at now the duty bearers, as it were, and then we balance everything. I don't know if I have left any other question. Thank you very much.
If I can just also add into the question around constitutionalism in our context, I would like to believe we are doing well. It's okay, if I can say, because you find, particularly in most rural areas that some of our organizations operate in, constitutionalism is taking place, but it has just not been named and framed as such. There are issues that citizens deal with on a daily basis that they meet in different platforms to address, but we are there to then go in and guide them in terms of what the Constitution should say. But I believe these are issues that ordinary citizens are engaging in. Even if you look at the Marange issue, it was started by the citizens themselves. We then went in to probably give advice around litigatory issues, but these are the platforms, indigenous platforms that exist that allow citizens to come in and have certain issues raised and addressed, but they've just not been named and framed as such. So I believe our role then is to go in as CSOs, as CBOs, to then frame them in the context of the Zimbabwe Constitution. And then in terms of the power to make and unmake laws being in the hands of perhaps a certain party, I believe we're also doing okay in terms of the way we've managed to mobilize citizens to participate perhaps in bill hearings. And for those who have participated in those processes, I've personally been impressed in the way citizens are able to articulate their issues when it comes to contesting some of the laws or clauses that are in some of those bills that are there. So in terms of mobilization and getting citizens to participate in these processes, I think we've just not documented enough, and if we have documented, we have not shared enough to show that constitutionalism is at play and is actually working, and we just need to continue going at it. Like Namatai says, we need to continue sitting under the trees and talking about these issues, and that's how we develop the constitutionalism that is taking place currently. Thank you.
So I just wanted to add something on the laws that are being made by Parliament that are oppressive and are against human rights. My brother, just to answer you, Parliament can make any laws it wishes to make, because that's their mandate, isn't it? But also those laws would then be looked at in the context of the Constitution. When you look at Section 2 of that Constitution, and I think Dr. Kika mentioned it earlier, that the Constitution is the supreme law of Zimbabwe, and any law that is inconsistent which is inconsistent, it will be held to be invalid to the extent of that inconsistency, isn't it? So I think a few months ago or so, Walpole was being charged with criminal defamation. And that particular provision had been held unconstitutional. Eventually the charges were thrown out. So you can make laws that don't have any meaning. The courts will then ensure that they declare them invalid or unconstitutional, and then you won't be able to use that law against any person. But I think the idea, obviously, is that civil society organizations and lawyers must then be vigilant and continue to challenge such repressive laws, so that nobody is persecuted using oppressive and suppressive laws. Thank you.
Over to you, Bodono.
Thank you to our panelists and for the audience for those questions. We'll just open up another round of questions, comments, if there are. Doesn't look like it.
Thank you so much, everyone. And also thanks for your patience. Yes, just to make sure that, and we're hoping that partners that are here in the room would help us in disseminating the booklets, but also taking it to your constituencies. I mean, we are in South Africa, and we can't do this from South Africa. At the heart of it, we also want to see local partners taking ownership. So if you do want to be part of post-launch interventions, advocacy trainings, just speak to Tariro and give her your details so that we can take this message to the people. And I just also want to say thank you again for joining us. Thank you again to our partners, the University of Zimbabwe, excuse me, the Law Faculty and the Forum. It's been such a rich conversation. I'm hoping that we can take the conversation further. We had a little bit of issues with the booklets getting here, but I understand that they would be here soon. There was a bit of a delay at the border, blah, blah, blah. So hopefully by the time they get here, you'll still be here, so we can give you a copy, but if not, we will leave a few of them with the Forum, with Zimbabwean human rights lawyers, and with the university, and our local partners here would help us to ensure that you get them. And lastly, Africans don't gather without food, right? Yes. And since we're also talking about our rights, I think we should exercise our right to food. So lunch will be served on this ground floor, Terry? Yes, at the restaurant on ground floor, but also more importantly, there are a few people who came in a little late and have not registered. If you can, please, there was at the back, but there's also some going around. Okay, so apparently there's a registration form going around there with Lucy, but there's more at the back. We would like to keep in touch. So yeah, thank you so much. We really appreciate you spending time with us. Let's go eat. Thank you.